adorable.
So my name's John Therien, and I've been associated with the Chordoma Foundation since November 2007. I got involved through Carrie Shad, who I think many of you know and who wanted to be here today. She's a partner at my law firm, and the Chordoma Foundation was looking for a lawyer to help them with all these wonderful research collaborations that we all heard about yesterday from a legal side. And so Carrie asked me if I would jump in, and I've been working with the Chordoma Foundation ever since. This is my first time at a community conference, and Heather asked us what our takeaways were this morning, and I didn't get up this morning, but I would like to briefly share my takeaway, which is how impressed I am with the strength and commitment and openness of this community. I'm not a Chordoma survivor myself. I don't have a family member who's been affected by Chordoma, but I have really felt privileged to be involved in this very personal gathering of your community. It's been an honor. I guess my second quick takeaway is how excited I am to see what the Chordoma Foundation has achieved and how quickly they've achieved it. And I've really felt privileged to be helping them in that task, and I'm going to continue to do that. So Simone asked me today if I would talk about advanced healthcare directives from a legal perspective. And that is my goal of this talk today. I want to help you understand what options are available. I want to make sure that you can put your hands on the right legal documents that will help you to implement your decisions regarding healthcare in a situation where you might not be able to voice those decisions yourself because of incapacity or end-of-life issues. And hopefully once you have these documents, it'll enable you to make sure that the wishes that you have today for your health care if you become incapacitated will be carried out. So I'll be talking about what are advanced healthcare directives, what do you need to do to make sure that the document that you put in place is effective, what should you do with it once you've created one, and then why do you need one? What might happen if you don't have one? Advanced directives are legal documents that guide decision-making for healthcare when you're unable to make decisions. It can be a very detailed document that specifies exactly what instructions you want followed and under what circumstances. It also can be a document where you give another trusted person the right to make healthcare decisions in your stead if you become incapacitated. I'm a lawyer in North Carolina. I suspect that there are probably at least 10, if not 15 states represented in this room, and every state in the United States, and I understand probably Canada as well, regulates advanced directives differently. And so if you have questions, please feel free to ask. I may not know the answer because each state is different, but thankfully there are great resources available on the internet that can tell you exactly what you need for your state in particular. The major types of advanced healthcare directives really it's the first two, and these are just two of the names by which they go. They're commonly called a healthcare power of attorney. It's also known as a healthcare proxy, a living will, which can also be called a healthcare directive, and then a do not resuscitate order, which is a document that you prepare together with your doctor. You can't do this one on your own, and there are certain circumstances in which each of these documents can be helpful. They complement each other, and they're all designed to ensure that your wishes about your health care are followed. The healthcare power of attorney is a document in which you grant to a trusted third person the right to make decisions on your behalf. Typically, you would name the person that you are most comfortable with. It could be a family member. It could be a close friend. Generally, as a matter of state law, it can't be your doctor. It can't be an employee of the institution that's providing health care to you. But other than that, you can grant this responsibility and right to any adult. You probably want to make sure that the person that you pick can be an advocate for you. Simone talked yesterday about being your own advocate, and I think that's one of the qualities that you should look for in a person to whom you might grant this responsibility to get up and ask doctors about what the best care is and make sure that they can stand for you and make sure that the best decisions are being made. A healthcare power of attorney becomes effective when a doctor determines in writing that you do not have the capacity to make healthcare decisions on your own. The actual sort of language varies from state to state, but essentially it's an inability to make the decisions because of a lack of understanding of the situation. The agent makes a decision in your place. Typically, the agent can make all healthcare decisions unless you limit the agent's authority. So that would include things like artificial nutrition and hydration if it was a very serious situation. It also can include, in some states, commitment to a mental institution. It's any kind of decision that you could make on your own, you're giving the responsibility to this third party to make. So it's important that you know them well and that they know you well and that you trust the decisions that they would make. It applies both in cases of temporary and permanent incapacity. So this is really an important document not only for end-of-life care, but for any situation in which it's possible that you may become incapacitated. It's really a good idea for everyone to have one, because who knows what will happen to us as we're walking down the street. We may get injured and we may not be able to express the wishes, or we may not yet have formulated the wishes that we would like to have followed in that case. And so it's a great document for everybody to think about. If your temporary incapacity goes away, your agent loses the right and responsibility to make decisions for you, and it reverts back to you. So it's a document that can turn on and off, and it's a document that you can talk with your agent over the years in which it's in place to make sure that as your wishes regarding health care evolve, your agent understands that and can make those decisions for you if you're not able. The decision making of the agent, I guess there's sort of three levels of it. If there are specific instructions that you've given your agent has to follow those. If you haven't done that, then your agent tries to make the best decision for you as if they were making the decision in your place. So the better they know you, the better they'll be able to make that decision. If for some reason you have an agent who doesn't really know very much about you, then they just use their own judgment to decide what they think is in your best interest. So it really is a good idea to talk about healthcare decisions with your agent. You can appoint more than one agent. They can't act at the same time, but again, this is a good idea. So if you have a person who might be unavailable in a certain situation, you can have an alternate who will step in and have the same authority and responsibility as your first designee. One of the keys about the healthcare power of attorney is that it provides to a person you trust flexibility to respond to unforeseen situations. You don't really know what kind of decisions will have to be made. And so, although you can put detailed instructions regarding various situations into your healthcare power of attorney, there's sort of a tension between making sure that your wishes are followed and giving your healthcare agent the flexibility to respond in their judgment on your behalf. The next document is the living will. And sort of the context in which this comes up is that each of us has a constitutional right to refuse medical care, including life-sustaining treatments like artificial nutrition and hydration. And this is a document that really comes into play in end-of-life situations where you can't communicate your desire to have a life-sustaining measure withheld. You can specify in advance, this is what I would want to happen if, for example, I'm in a coma from which the doctor doesn't believe that I will come back. There are a couple of alternate names up there by which you might have heard it. I think one of the key distinctions between these two documents and why you can look at them as complementary is that the healthcare power of attorney really is about giving somebody else the right and responsibility to make decisions on your behalf, but you don't have to specify what those decisions would be. It's putting your life and decisions in the hands of another. This really is a specific directive. I want this to be done under these situations. And so your healthcare agent can listen to your living will and know what to do in those particular situations. But even if you don't have a healthcare agent, your doctor typically will be obliged to comply with this, although there are situations for religious, moral, or ethical reasons where physicians or institutions are not obliged to comply with it. So it's important, and a later slide notes that you should talk with your doctor to make sure that they will abide by your wishes in your living will. I guess the key point here is that by putting in place a living will, the real value of it to your family members is that they will know when you can no longer communicate with them what your wishes are, and so they can have comfort that they're complying with your wishes in a situation where you're no longer able to communicate them. To revoke a living will, you just have to indicate to your physician or anyone around you who's involved in your healthcare decision making that you don't want this to be in place anymore, and that is regardless of your capacity. If you can communicate that information because of your constitutional right to refuse medical care, you can change your living will. A healthcare power of attorney is slightly different, and I didn't mention it on the last slide. If you're in a situation where you lack capacity, you can't revoke that until you get back into a situation where you have capacity to make medical decisions. So do not resuscitate order. This one is a little different from the other three I mentioned. You can't prepare it yourself. And this deals only with CPR. Emergency medical care, whether it's in the hospital or in your home, the technicians that perform emergency medical care are obliged to stabilize a patient. So unless there's something that tells them not to, if they find that your heart has stopped or your breathing has stopped, they will perform CPR. And so a do not resuscitate order is an override on that, which you can prepare only with a physician. Typically, it will function only in the hospital setting where you're receiving care from physicians. It should travel with you from facility to facility, but it would be good for your family or friends or whoever is helping you in this time of crisis to make sure that it has been transferred over to a new facility. Some states allow for what's called a portable DNR order, and this is in a hospice or non-physician care setting. It can be a bracelet or it can be a document that will alert emergency medical technicians if they find you with your heart or breathing stopped not to perform CPR. So how do we get an advance directive in place? Like I said, it varies from state to state. All 50 states have slightly different forms, slightly different requirements, and the scope covered by these documents varies as well. Some states actually allow an out-of-state healthcare power of attorney or living will to be valid in that state if it meets their requirements. The specific instructions, and I'll give you a website at the end of all this that will allow you just to navigate to your state to find exactly the documents that you need, and that will give you detailed instructions that are specific to your state. Generally, there are a few requirements that apply across states, and one is that in order to execute a healthcare power of attorney or a living will, you have to be an adult as defined by that state, typically 18. Some states vary on that. It has to be witnessed, and typically those witnesses have to be adults. In some cases, they're not permitted to be family members. They have to be disinterested observers. In some cases, they're not permitted to be your physician. So in some cases, a notary will suffice. So it varies, but the forms that I'll direct you to do give you specific instructions on a state-by-state basis. One of the things to note about this is that although I am a lawyer, you don't need a lawyer to fill out these forms. They are all, the language of them is dictated by statute, and they're designed to be something that people can put in place without calling up a lawyer and incurring legal fees and all those things that sort of negatives associated with lawyers. So where can you get these sample forms? I would say that the best place actually is the last bullet point that I have there. Caring Connections, which is a national hospice and palliative care organization. They have just a list of 50 states that you can click on your state and find out what's permitted, what's required, and how to get effective documents in place in your state. Various state agencies and state bar associations, and there's a handout, which I should have mentioned at the beginning, that covers all the information that I'm talking about in more detail, and it also provides you with this website. So those are at the center of your tables, and you should feel free to take those with you. So, yes?
Do you need both the health care power of attorney and the living will?
Well, that's a good question. I think that they are complementary documents, and it makes good sense to have both because the living will provides specific instructions within a narrow set of circumstances. Your agent, if you have a healthcare agent who's making decisions for you, will know that he or she is acting in accordance with your wishes. If you don't have an agent, it's still valuable to have a living will, but the documents really complement each other well in that they help guide your agent when you can't make decisions, and so I recommend doing both.
And can you have two agents in the living will?
Well, there is no agent in the living will. So the way the two documents function is a healthcare power of attorney gives a right to a third party to make the decisions for you. A living will tells your doctor, I don't want this kind of extraordinary life-sustaining measures under these circumstances, regardless of whether you have an agent. It's a document that speaks for you as if there were an agent there to say it, but it's just a document. Mm-hmm.
But for the living will, there are still those circumstances that are less than clear. For example, the respirator. There are cases in which it would be used to prolong life. There are other cases in which there might be a trial basis to see if one responds. That seems to be very difficult to communicate that kind of situation. Same for antibiotic treatment. Mm-hmm. You can say, no, I don't want antibiotics because you don't want them to prolong life unnecessarily if you're clearly going to die. On the other hand, if it's a trial to see if one would respond and get back some quality of life. But that is what seems to be very difficult to communicate in the living will as opposed to the advance directive. And yet that is where the issue comes. Is this truly an end-of-life situation in which the living will applies, or is this one of those situations in which a trial might be of a couple of days, might be called for? And then the judgment has to come on, ultimately, the person you've selected in your advance directive to make that decision if they're permitted to.
Right.
Another issue.
There definitely is a difficult gray area between something that might be really life-sustaining with no chance of a return to a cognitive state, or where there's still some hope left. And most state statutes that have living wills try to describe that situation, but it's difficult. And so and that's a great reason to have a healthcare power of attorney and a healthcare agent, someone whose judgment you can trust in that situation, rather than just the letters on the page of
that's very hard.
The living will.
It's likely to do that are members of your family who are going to be more swayed by emotion rather than necessarily reason and medical knowledge.
It's true. It is.
So I just make a suggestion. I work in healthcare, and there's been so much change for the better for families of people that are going through problems. Whereas before, where you didn't have the healthcare proxy, one of the things that's really important is whoever that healthcare proxy is that, that there are family meetings and that they're communicated with that one individual with other people around, so that you don't get that. You can't have a living will with all the different decisions. You try to flow out every possible scenario, and there are just so many. But I think that when it comes down to it, whoever you pick for your healthcare proxy, be surrounded by a good group that's supportive.
You must consult together. That would be a good thing.
And then having that information be funneled through that one person, because when you have so many family members and they're all trying to say their own opinion, it gets very difficult for the medical decision, on the other end, how you want to proceed. So I think it's most important. Emotions do play a huge factor. And so it's so important that you all come together and then work with whoever that healthcare proxy is, to help give what it is that individual really truly wants it.
I think that's a great point. Communication is critical.
Somebody would lead.
Even though that, say you're our healthcare proxy, and we're all a big family, and everybody has their own opinion of what it is, but it's so important to sit down with that doctor and have them be able to voice their opinion. So if you are the healthcare proxy, and you may not know everything about that person's wish, but that you all come together, that you have that understanding, and that you communicate together. Because, no one, if it's me that's dying or I have some decisions that need to be made that I can't make, I need all of my family members to be able to come together to provide the best things that I would want as an individual, because it just gets so, stressful for everyone.
I'm trying to have all members of my family read a book called Talking About Death Won't Kill You, and it talks about all the possibilities and how it can go awry. And, I do know that my husband will have a hard time making that decision, but my younger daughter would do really well, but he's the one who's going to probably be with me more likely. So, those things are the harder things. The implementation rather than the theory is where
But really, family members can support if your husband is the healthcare decision maker, but knowing that all those things can be discussed when you're feeling good. And it's not something everybody wants to talk about, but we all he has got some Chordoma, but who knows what's going to happen? We all have life decisions that we need to talk about. We all have older parents and have gone through things, so lots of change. Communication is the most important. Sorry.
No, thank you. So once you have filled out your forms, I think the principles really on this slide are about access and communication, as you just said, that everybody needs to know that you have a healthcare power of attorney or a living will. Everyone who's involved in your healthcare, they need to know how to get to it. You shouldn't put it in a safe deposit box or anything like that, because it's a document that will need to play a significant role when you're no longer able to communicate your decisions. And I think, what's that?
So put it in your car glove compartment. That's where you're
right.
Your family member will have it there.
And it's important to have the discussions with your healthcare providers and your family members about what you mean for this document to achieve, and to make sure that the documents are consistent. And the forms that you'll see if you go to the website that I mentioned typically will have a sort of, this is an override on, this living will statement is an override on my healthcare power of attorney's right to make decisions because I want this decision made this way, or you can flip it the other way and say that this is my preference if my agent is unable to make decisions on my behalf, but otherwise I would rather have this person make the judgment in my place. And I mentioned earlier, it's important to talk with your physician about whether they'll honor your advance directive, because physicians and institutions are allowed not to honor them if it's inconsistent with their religious, moral, or ethical beliefs. And so if that's the situation, it's something that you should know going into care with that particular physician, and whether that makes an impact on who you want to receive care from. What's that?
There's a hospital in our local area that won't follow the advance directive.
And so I guess the risk in not having an advance directive is that state law then directs who makes the decisions, and laws vary from state to state. It may say that the family makes the decisions, but it may select a family member that you're not the most comfortable with as your primary decision maker, but just because whether it's your spouse or your eldest child, it may not be the person you want to speak in your stead. There are some states that don't permit the family primary decision-making rights if the patient becomes incapacitated. In those situations, unless there's a clear statement of what the patient wanted or a legally designated decision maker, technically the decision about care falls to the medical team. Now, as a practical matter, they should be listening to the family, but it can be a difficult situation if there's not a person that you're close to that has the authority to make those decisions. And I guess I'll just close with the statement that letting your loved ones know what you want so that they have the comfort of knowing that they're complying with what you would have wanted to the greatest extent possible, to the extent that you can convey that, really is a gift that you can provide to them. So that's it. And like I said, there's a guide on your table with more detailed information on all of this. And I didn't really get into particular language or what the documents look like because they vary so much from state to state. But I would encourage you to take a look at that website and consider putting in place one or more of these sorts of documents. And if there are any questions, I'd be happy to take them. Yes.
This is not a question, it's a point to make. Considering the DNR paperwork, my mother was in hospice and dealing with her issues. She did have a DNR. Mm-hmm. She also had a pacemaker. And if she went into cardiac arrest and the emergency people called in, they were obligated, as you just said, to perform measures to try to resuscitate her, and yet she had this DNR. So that's just a point to bring up to people. If you have family members with a pacemaker, what you need to do is have that pacemaker uninstalled or disconnected. And that was a tough decision to make, so that my mother's wishes of DNR could be met. So just a little, as you said, there's a lot of gray area there. Mm-hmm. I think you've got all this paperwork lined up and taken care of, but then these situations come up that you just don't expect. So mm-hmm. Just a real life situation to share.
Well, thank you.
Thank you.